the news just keeps getting better and better. A judge just ordered 45 to turn over 8 years of tax returns to the Manhattan District Attorney's Office. A federal judge on Monday rejected an argument from, and I don't consider it a bold argument because really 45 is trying to hide his tax returns. That's brilliant. A federal judge on Monday rejected a bold argument. I don't even know why they consider it bold because it really wasn't a bold one. From 45 that sitting presidents are immune from criminal investigations, which they're not, allowing the Manhattan District Attorney's Office to subpoena 8 years of the squatters' personal and corporate tax returns. Lawyers for 45 quickly told the court they would appeal the ruling from Judge Victor Marrero of Manhattan Federal Court that squatters' lawyers could not immediately be reached for a comment. In a 75-page ruling, Judge Marrero called the squatters' arguments repugnant to the nation's government structure and constitutional values. The squatters, their families, and businessmen are not above the law. Any squatter that's squatting in the White House like 45, their families and businesses are not above the law, the judge ruled. The judge's decision came a little more than a month after the Manhattan District Attorney subpoenaed 45's accounting firm, Mazars USA, for his personal and corporate returns dating 2011. The demand touched off a legal showdown that raised new constitutional questions and drew in the Justice Department, which supported the squatters' request to delay enforcement of the subpoena, which, of course, the judge ruled against his favor, which is a good thing. The Manhattan District Attorney, Cyrus Vance Jr., has been investigating whether any New York state laws were broken when 45 and his company reimbursed the squatter's former lawyer and fixer Michael Cohen for payments he made in the run-up to the 2016 election to the pornographic film star Stormy Daniels, she had stated that she had an affair with 45 of all the people she could fuck. Why fuck that ugly piece of shit? 45 has denied having an affair with Miss Daniels. I'm pretty sure that she told the truth and he's lying. 45's lawyers sued last month to block the subpoena, arguing that the Constitution effectively makes sitting presidents immune from all criminal inquiries until they leave the White House. Not true. The lawyers acknowledged that their argument had not been tested in courts, but said that the release of the squatters' tax returns would cause some irreparable harm. Mr. Vance's office asked Judge Marrero to dismiss 45's suit, saying a grand jury had a right to pursue any investigation free from interference in litigious delay, and rejecting his claim to blanket immunity. The judge was appointed by then President Bill Clinton at that time back in the 90s. 45's lawyers have called the investigation by Mr. Vance motivated, not true. Mr. Vance has accused the squatter and his team of trying to run out the clock on the investigation, which is what they've been trying to do all along. Last week, lawyers with 45's Justice Department jumped into the fray, asking the judge to temporarily block the subpoena while the court takes time to consider the significant constitutional issues in the case. The Justice Department, led by Attorney General Dumbass William Barr, did not say whether it agreed with 45's position that presidents cannot be investigated, but citing the constitutional questions, the department said it wanted to provide its views. The Constitution does not explicitly say whether squatters can be charged with a crime while in office, and the Supreme Court has not yet answered that question. Federal prosecutors are barred from charging a sitting president with a crime because the Justice Department has decided that presidents have temporary immunity while they're in office, while 45 does not. But in the past, this position has not precluded investigating the president. This does not include the squatter. 45 have been subject to federal criminal investigations while in office. Local prosecutors such as Mr. Vance are also not bound by the Justice Department's position. As part of a temporary deal reached last month, Mr. Vance's office agreed not to enforce the subpoena until 2 days after Judge Marrero issued a ruling which would give 45 a chance to appeal if he lost, but that agreement was to expire at 1 o'clock today. Writing to the judge late on Friday, William S. Consovoy, a lawyer for 45, all but demanded that the judge rule early on Monday in order that there will be time to appeal before the afternoon deadline. After 9 a.m., 45's lawyer wrote the squatter would not have enough time to ask to seek relief from the Second Circuit before Mazars discloses his confidential information. Mr. Consovoy said that if no ruling came by 9 a.m. on Monday, the squatter would interpret the judge's inaction as a denial of his request to block the subpoena, and he would appeal without waiting for a court decision.